the first thing you notice isn't the blood. It's the silence. Before we continue, please hit the like button, subscribe to the channel, and turn on the notification bell for updates. That's what several people close to this case have said, in different ways, without coordinating their language. Not the kind of silence that follows chaos. Not the stunned quiet after sirens fade. A deeper kind. The kind that exists before anyone knows what they're allowed to say out loud. Because when the deaths of Rob Reiner and his wife became public, the story moved fast. Too fast, some would later argue. Headlines stacked up. Names were printed. Charges were announced. A suspect was identified. A narrative, neat and brutal, began to form. But the truth, whatever it is, didn't arrive with the headlines. It arrived in fragments. In pauses. In what wasn't said. And in the words of the youngest daughter. Or rather, in the fact that she didn't speak at all. Not at first. Let's slow this down. Because this isn't just a story about a violent night in a wealthy neighborhood. It isn't only about a famous father, a private family, or a son now facing the most serious accusation imaginable. It's about timing. About who speaks first and who waits. About the strange power of restraint when everything around you is demanding noise. And it's about a moment, quiet, easily overlooked. When someone inside the family pointed, not publicly, not dramatically, but deliberately, toward danger. Before the world was watching. Before the cameras arrived. Before the story decided what it thought it already knew. The public version begins on a Sunday night. It always does. A date, an address, a confirmation. The deaths of Rob Reiner, 78, and his wife, Michelle, 70, discovered inside their Brentwood estate. The word, stabbed, appearing in early reports. The setting described in careful real estate shorthand, a $13.5 million property in Brentwood. Quiet, leafy, secure. The kind of place people associate with distance from danger. But danger doesn't ask for permission. Within hours, the focus narrowed. Their son, Nick Reiner, 32, arrested that same night. 2 counts of first-degree murder. A legal framing so severe it barely leaves room to breathe once it's spoken. And just like that, the story seemed complete. Except it wasn't. Because tucked inside the early reporting was a detail that didn't quite fit. A line that didn't get the headline treatment. A sentence that didn't match the speed of everything else. The bodies, reports claimed, were discovered by the Reiner's daughter. Not the son, not staff, not security. Their daughter, 27 years old. The youngest, Romy Reiner. And according to those same reports, she told police something else. Something specific. Something loaded. That there was a dangerous family member. That this person should be a suspect. Now pause there. Because if you're watching this, or listening, or even just thinking about it for a moment, that line should make you uncomfortable. Not because it's dramatic, but because of what it implies. Who says that? Who, in the immediate aftermath of discovering their parents dead, frames danger in those terms? Not, I don't know what happened. Not, this is impossible. But dangerous. A word chosen carefully. A word with consequences. And yet, she didn't go on television. She didn't release a statement. She didn't sit for interviews or leak emotional details to the press. She spoke once. To law enforcement. And then she disappeared from the public narrative. That absence matters. In cases like this, silence is rarely accidental. It can be grief. It can be fear. It can be legal advice. Often it's all three, tangled together in ways that don't make sense until much later. Here's the uncomfortable truth. The first version of any breaking story is almost always wrong, or at least incomplete, especially when the people involved are famous, especially when the crime is violent, especially when there's a family member who fits neatly into the role of suspect. The world likes clean arcs, heroes and villains, before and after, but families don't work that way, and neither do investigations. What makes this case different, and why it matters now, is not the arrest itself. It's not even the charges, as staggering as they are. It's the fact that investigators appear to have been guided early on by someone who knew the house, the dynamics, the patterns, the tensions. Someone who didn't speculate publicly. Someone who didn't need to explain her words. Someone who knew exactly what she was doing when she used the word dangerous. Ask yourself this. If you were in her position, would you speak that plainly? Would you point inward, toward your own family, while the shock was still fresh? Or would you hesitate, soften, protect? And if you did speak, would you ever speak again? The public hasn't heard from Rob Reiner. Not in interviews. Not in statements. Not in court filings released so far. Her voice exists only in reported fragments, filtered through police summaries and early accounts. That's not an accident. Because in high-profile cases like this, what's said early can never be unsaid. Words become exhibits. Phrases are replayed. Tone is analyzed. Silence itself becomes suspicious. So when someone chooses restraint, real restraint, it often signals something else entirely. Awareness. Awareness of what's coming. Awareness of what hasn't yet surfaced. Awareness that the truth, when it finally emerges, may not align with the version people are rushing to accept. Let's be clear about something. At this stage, everything is alleged. Charges are not convictions. Arrests are not conclusions. And family dynamics, no matter how fractured or painful, are not proof of guilt. But neither are they irrelevant. In this case, sits at the uncomfortable intersection of all of it. A father whose public life was built on storytelling, humor, and moral clarity. A family whose private life, like all families, was never meant for public dissection. A son now accused of doing the unthinkable. And a daughter who, quietly, early, pointed toward danger. And then stepped back. There's a temptation to treat this as a tragedy already solved. To let the legal process play out in the background while the public moves on, satisfied that the outline is clear. But it isn't. Because there are questions no headline has answered. Why did the discovery happen when it did? Why was the guest house relevant? Why did law enforcement move with such speed? And why does the youngest daughter's role remain so carefully undefined? Those questions don't exist to cast doubt for the sake of doubt. They exist because stories like this are rarely as simple as they're presented in the first 24 hours. And because somewhere between grief and accusation, between silence and statement, something else is forming. Something slower. Something harder to categorize. As we move forward, we're not going to rush this. We're not going to shout. We're not going to pretend we know more than we do. We're going to do something far less comfortable. We're going to sit with the unease. We're going to trace the timeline before the night everything ended. We're going to look at the house, the separations, the proximity, the quiet warning signs that rarely make it into press releases. And we're going to keep coming back to the same question, even when it's inconvenient. Why was the first alarm raised not by evidence, but by someone who knew the danger personally? Because once you ask that question honestly, the story stops being about a single night and starts being about everything that led up to it. And what may still be waiting beneath the surface. What does it mean when a night doesn't announce itself? No warning, no build-up, just a normal evening that quietly tips into something irreversible. That question hangs over the first hours of this case, because when investigators later tried to reconstruct what happened, they didn't start with chaos. They started with routine, with expectation, with the assumption that nothing was wrong until suddenly, unmistakably, it was. This wasn't a scene that exploded into public view. It unfolded behind walls, behind locked doors, behind the kind of privacy money is supposed to buy. And that's where the story really begins. Not with sirens, not with arrests, but with time. Time passing without interruption. Time passing without anyone outside the house realizing that something inside it had already gone terribly off course. The timeline that night is deceptively simple on paper. Too simple. A Sunday. A high-end home in Brentwood. No reports of disturbance from neighbors. No frantic calls logged early in the evening. No visible emergency until much later. That absence is important, because in violent crimes, especially those involving family members, there's often noise before the break. Arguments heard, doors slammed, raised voices, something that leaks beyond the walls. Here, according to early reporting and later confirmation, there was none of that. Which raises the first uncomfortable possibility. Whatever happened didn't look like a sudden eruption. It may have looked normal. Think about that for a moment. A house where everyone knows each other's rhythms. A place where movements aren't questioned because they're familiar. Where a person walking from one part of the property to another doesn't raise alarms. Familiarity can be a kind of camouflage. By the time the discovery was made, hours had passed. How many is still a matter of careful wording in official documents. But enough for one crucial thing to be true. The window in which intervention was possible had already closed. And the person who crossed that threshold, the one who realized something was wrong, wasn't law enforcement. It wasn't security. It wasn't a neighbor responding to noise. It was family. That detail alone changes how we have to read everything that follows. Because discovering a crime is not the same as witnessing one. Discovery is slower. It involves confusion, denial, the instinct to explain away what your eyes are telling you, the instinct to assume there must be another answer. People don't immediately jump to the worst conclusion when the worst conclusion involves someone they love. And yet, in this case, something happened very quickly after that discovery. A decision was made. Words were chosen. Law enforcement was contacted. And from the moment police entered the property, the case accelerated. Investigators didn't treat this as an open-ended mystery for long. Within hours, focus narrowed. Attention fixed on someone who, on paper, made sense. Proximity, access, presence. Nick Reiner was living on the property at the time, in a guest house. That fact was included early, almost casually, in reports. As if it were just a logistical note. It wasn't. Ghost houses occupy a strange psychological space. They suggest separation while preserving closeness. Independence without distance. A boundary that exists architecturally, but not emotionally. You're not fully inside the main home, but you're not really outside it either. That matters when investigators start asking questions about access, about movement, about who could come and go without drawing attention. And it matters when we think about why nothing seemed out of place for so long. The arrest came quickly. That speed became part of the story almost immediately. 2 counts of first-degree murder. The most serious charge available. A legal posture that suggests certainty, or at least confidence. But speed in cases like this cuts 2 ways. On one hand, it can mean evidence is strong. That something at the scene, something undeniable, pointed clearly in one direction. On the other, speed can also be a response to pressure, to visibility, to the presence of a famous name and the unspoken demand that the case be contained before speculation runs wild. Which was it here? That question hasn't been answered publicly. What we do know is that once the arrest was made, the narrative began to solidify. Headlines followed a familiar arc. A troubled son, a violent act, a tragic end. The story became clean. Too clean. Because in the background of that rapid legal movement was something slower, quieter, and far more complicated. A family processing loss in real time. A daughter who had just made a discovery no one should have to make. And a warning that didn't sound like hysteria. It sounded measured. When police documents later referenced the phrase, dangerous family member, it stood out to investigators and journalists alike. Not because it was emotional, it wasn't. But because it was precise. Dangerous is not a word people reach for casually. It's not the language of shock. It's the language of assessment. An assessment implies history. You don't assess danger based on a single moment. You assess it based on patterns. On things you've seen before. On behaviors that made you uneasy long before they became relevant to an investigation. Which leads us to an uncomfortable realization. Whatever unfolded that night did not begin that night. The timeline doesn't start with the discovery. It starts earlier, much earlier, with tensions that may not have been visible to outsiders, with dynamics that didn't register as urgent until suddenly they were everything. Here's where the story resists simplification. Because families with famous parents are often assumed to be either glamorous or broken, with very little room in between. But real families exist in the middle, in contradiction. In long stretches of apparent calm punctuated by moments of strain. And strain doesn't announce itself with crime scene tape. It announces itself in tone, in distance, in conversations that end too quickly, in arguments that never quite resolve. We don't yet know which of those applied here. But we know enough to say this. By the time law enforcement arrived, someone inside the family had already connected dots the public hadn't seen. That matters because investigations don't happen in a vacuum. They're shaped, especially early on, by the information given by those closest to the situation. Who called, what they said, how they said it. Those details steer everything that follows. And once a direction is set, it takes something extraordinary to change it. So ask yourself this, and be honest. If the first person to raise concern points toward a specific kind of danger, how much weight does that carry? How much does it narrow the lens through which everything else is viewed? It's not proof, but it's not nothing either. As the night turned into early morning, law enforcement worked quickly to secure the property. Evidence was collected. Statements were taken. A picture began to form, though parts of it were still blurry. And while the public would soon be introduced to the case through a handful of definitive-sounding headlines, the people inside it were still operating in shock. Grief doesn't arrive on schedule. Neither does clarity. And yet, decisions were being made that would shape the rest of this story. Charges were filed. Names were released. And a family tragedy became a national headline. But the night itself, the hours between normalcy and discovery, remained strangely opaque. What conversations happened earlier that day? Who saw whom? And when? What was said and what went unsaid? Those questions aren't gaps in reporting. They're gaps in understanding. And they're gaps that matter. Because when a case hinges on familiarity, on who knew the house, the routines, the emotional terrain, the smallest details become critical. A door left unlocked, a light left on, a movement that didn't seem suspicious because it never had before. These are the things that don't make it into the first wave of coverage, but they're the things that later decide whether the early narrative holds. As investigators continue to build their case, one thing becomes increasingly clear. This was not a crime of strangers. There was no forced entry, no external threat identified. Whatever happened was intimate, contained, which makes the silence before discovery even more unsettling. Silence doesn't just mean absence of sound. It can also mean absence of interruption, absence of anyone thinking to check in, absence of urgency, and absence, in hindsight, is often the loudest clue of all. Because if nothing seemed wrong, why not? That's the question that lingers over the first night. Not what happened, not yet, but why it took so long for anyone to realize something had gone wrong. And why, when that realization finally came, it arrived with such startling certainty about where danger lay. The night didn't erupt. It didn't spiral. It closed in on itself. And by the time the world learned about it, the most important decisions had already been made. Decisions that would define the case. Decisions that may still be challenged. And decisions that hinge, in no small part, on what one daughter recognized in a moment when denial would have been easier. But that recognition didn't come out of nowhere. It came from somewhere deeper. And that's where this story is heading next. Because before the night ended everything, there was a house that shaped how it could happen at all, and what that house allowed and concealed. Maybe the key to understanding why the silence lasted as long as it did. A house doesn't just hold people, it shapes them. That idea sounds abstract until you're forced to confront it under pressure, until a space you thought you understood becomes part of an investigation, part of a theory, part of a case file. Because once investigators began looking closely at this property, the question quietly shifted. Not who, but how. How could something so catastrophic unfold without triggering alarms? How could movement go unnoticed? How could time pass, real time, measurable time, without interruption? Those questions don't lead to psychology first. They lead to architecture. The Reiner estate in Brentwood wasn't unusual for the area. Large, private, carefully landscaped, designed to separate public-facing spaces from personal ones. Designed, like many homes at that level, to create layers. Layers are comforting. They're also dangerous, because layers create blind spots. From the outside, it's easy to imagine a single house. One roof, one interior, one shared space. That's not how these properties work. Not emotionally, and not practically. There's the main residence. Then there are secondary structures, ghost houses, detached wings, transitional spaces, patios, walkways, courtyards, that allow movement without visibility. That matters when investigators ask a very specific kind of question. Who could move freely without being noticed? Someone unfamiliar with the property would hesitate. They'd check lights, listen, worry about being seen. Someone who lived there wouldn't. Familiarity removes friction. It's why the presence of a guest house was not just a background detail. It was a structural fact with investigative consequences. Living in a guest house means you are both present and absent, close enough to be part of daily life, separate enough to avoid scrutiny. You don't knock in the same way. You don't announce yourself. Your comings and goings don't register as events. They register as routine, and routine is invisible. Think about how many times someone crosses a space in a home without thinking. How many movements your brain filters out because they've never been a problem before. Now imagine that same filtering applied to an entire property. The night of the crime, There were no reports of forced entry, no broken windows. Because in high-profile cases, certain information is released strategically. Other information is held back deliberately, and the reasons for holding back are rarely benign. Sometimes it's about protecting the investigation. Sometimes it's about protecting people. Sometimes it's about protecting a narrative until it's legally useful. What we do know is that once the threshold was crossed, once the discovery was made, the house transformed from home to evidence. Every space became relevant. Every path became traceable. Every assumption about privacy became suspect. The guest house, in particular, took on new significance. Not because it proved anything by itself, but because it complicated the idea of separation. Living in a guest house suggests autonomy, independence, a degree of removal from daily family life. But it also means something else. You're close enough to observe without being observed. You can hear things others might miss. See lights turn off. Notice patterns. And you can move without explanation. That duality is not incriminating, but it is consequential. Because when a crime involves people who know each other intimately, opportunity is rarely about brute force. It's about timing, about knowing when no one will intervene. And that knowledge comes from living inside the system. This is where the story resists easy conclusions. Because the house didn't just allow access. It allowed assumptions. Assumptions that everything was fine. Assumptions that privacy equaled peace. Assumptions that familiarity equaled safety. Those assumptions are what kept the night quiet. They're also what make the eventual discovery so devastating. Imagine walking into a space you know better than almost anyone else. A space that has always meant stability, and realizing that it has become something else entirely. That moment is not cinematic. It's disorienting, and it forces a decision. Do you deny what you're seeing? Or do you accept it immediately and act accordingly? The reported language used with police suggests acceptance came fast, which brings us back, again, to assessment, to the idea that what happened that night was not entirely unthinkable to at least one person involved. That doesn't mean it was expected. It doesn't mean it was planned. It means that, when faced with the unthinkable, the mind reached for an explanation that already existed somewhere beneath the surface. That's a hard truth to sit with, because it implies a before that hasn't been fully explored. What tensions existed inside that house before it became a crime scene? What patterns were already in place? What behaviors had been normalized, minimized, or quietly managed? Those questions are uncomfortable precisely because they don't lead to neat answers. They lead to ambiguity. And ambiguity is not something the public likes, but it's something investigations depend on. As the property was secured and the family's world fractured into legal processes and private grief, the house itself became silent again. Not the comfortable silence of routine, the charged silence of evidence preserved. And inside that silence are answers that haven't yet been made public. Answers about movement, about access, about the moments when intervention might have been possible and why it wasn't. We're told to focus on the night, on the violence, on the arrest. But the architecture of this story insists on something else. It insists we look at the spaces that made the night possible, the spaces that allowed assumptions to persist, the spaces that blurred the line between presence and absence. Because before there was a crime scene, there was a home. And before there was an arrest, there was familiarity. And before anyone used the word dangerous, there was a pattern that made silence feel normal. That pattern didn't begin on a Sunday night. It was built over time. And to understand what happened, we have to understand what came before. Not the headlines, not the charges, but the quiet dynamics of a family living in a house designed to keep the outside world at bay. Because once you understand that, the next question becomes unavoidable. If the house shaped the opportunity, what did the family dynamics shape? And that's where this story turns next. If the house provided the structure, the family dynamics provided the pressure. And pressure, when it builds quietly, doesn't always look like conflict. Sometimes it looks like accommodation, like careful language, like everyone learning which topics to avoid, which moods to read, which moments to step around rather than step into. That's the part of this story that doesn't sit comfortably in police reports. Because law enforcement can map a property. They can timestamp phone calls. They can trace movements. What they can't easily document is atmosphere. And atmosphere matters. Inside families, especially families shaped by public life, success, expectation, conflict doesn't always explode. Often it compresses. It gets smaller, tighter, harder to see from the outside. You learn to manage it. You learn to live alongside it. You learn, sometimes without realizing it, to treat certain behaviors as background noise rather than warning signals. That's not negligence. It's adaptation. And adaptation can be dangerous. When investigators began speaking to people close to the family, they weren't just asking about the night in question. They were asking about the weeks before, the months before, the tone of conversations, the emotional weather. Questions like, was anything different lately? Did anyone seem more withdrawn, more agitated, more unpredictable? Those questions don't produce clean answers. People hedge. They qualify. They speak in half sentences. Because hindsight distorts memory, and no one wants to believe they missed something catastrophic, especially when the cost of missing it is this high. Here's where we need to be careful. This is not about assigning blame retroactively. It's about understanding context. And context is often built from contradictions. A son who is present but not fully integrated. A family that is close but compartmentalized. A household where independence is respected, maybe too much. In public, Rob Reiner's life was defined by clarity. His work dealt in moral stakes, human flaws, resolution. He built stories where motivations mattered and consequences followed. Private life doesn't offer that structure. Private life is messy. Motivations overlap. Consequences arrive late. People inside this family are said to have loved one another deeply. That's not in dispute. But love does not erase tension. Sometimes it conceals it. And sometimes it coexists with fear. The phrase that keeps resurfacing, dangerous family member, didn't emerge from nowhere. It emerged from a relationship. And relationships are histories. When you hear that phrase, it's tempting to imagine a single defining incident. A blow-up, a threat, something concrete. But often, danger is perceived cumulatively. A pattern of volatility, a pattern of emotional swings, a pattern of behaviors that don't quite cross a line until one day they do. Those patterns don't announce themselves with sirens. They announce themselves in subtle shifts, in the way conversations end abruptly, in the way people adjust their schedules, in the way someone is given space not just for independence, but for safety. It's worth asking, gently, without accusation, what kind of accommodations existed inside this family before that night? Who adjusted to whom? Who avoided what? Who learned to keep certain concerns private? Because families are ecosystems. They find equilibrium even when something is off, especially when something is off. And that equilibrium can last a long time, until it doesn't. One of the hardest parts of covering cases like this is resisting the urge to simplify, to flatten the emotional terrain into something easily digestible. Troubled son, tragic parents, sudden violence. That narrative skips over the middle. The middle is where life actually happens. The middle is where warning signs blur into normalcy. The middle is where people convince themselves that tomorrow will be calmer, better, easier. Investigators are acutely aware of this. It's why they spend so much time asking about the ordinary. What was a typical day like? Who ate together? Who didn't? Who stayed up late? Who kept to themselves? These questions sound banal. They aren't. They're how you understand proximity without surveillance, how you understand access without intent, and how you begin to see whether danger was an aberration or an escalation. There's another uncomfortable layer here. Families with public figures often develop an internal code of protection. Privacy is not just valued, it's enforced. Problems are handled internally. Struggles are kept out of view. That instinct can be healthy. It can also become a barrier. When something feels off, the impulse is often to manage it quietly rather than expose it to outsiders who might misunderstand or sensationalize it. That impulse may explain a great deal about why certain things weren't escalated earlier. Not because they weren't noticed, but because they were contained. And containment is a form of hope. Hope that things will settle. Hope that this phase will pass. Hope that what feels dangerous now won't become irreversible later. Hope, unfortunately, is not a safety plan. The youngest daughter's reported decision to speak so directly to police suggests that, at least for her, hope had reached its limit. That's a heavy thing to carry. To be the person who crosses the line from protection to exposure, from family loyalty to public consequence. That decision doesn't come from nowhere. It comes from a calculus that weighs silence against risk. and decides silence is no longer safer. We don't know when that calculus began. We don't know how many moments contributed to it. But we know it existed before the night everything ended. Because you don't assess danger in a vacuum. You assess it based on what you've already survived. As the investigation moved forward, law enforcement began the delicate task of separating grief from evidence. Statements were taken, timelines were cross-checked, contradictions were noted, and somewhere inside that process, the family's internal dynamics became part of the case. Not as gossip, not as judgment, but as context. Context that explains why certain movements were possible, why certain absences went unnoticed, why certain words were chosen under pressure. This is the part of the story that makes people uneasy, because it asks us to accept that tragedy often grows in ordinary soil, not in spectacle, not in obvious warning signs, but in everyday accommodations that feel reasonable until they aren't. So as we move forward, keep this in mind. What we're looking for is not a single moment that explains everything. We're looking for accumulation, for the slow build of tension that changes how people behave without them realizing it, for the family dynamics that shape perception long before they shaped headlines. Because once you understand that, the next phase of this story takes on a different weight. The arrest doesn't look like a beginning. It looks like a rupture, a moment when private patterns were forced into public view, and when silence, carefully maintained for years, finally broke. But what happens after silence breaks is rarely simple. And what comes next in this case will test not just the legal system, but the family itself. Because when a family's internal history becomes evidence, everyone is forced to confront things they once worked hard not to see. And the most difficult testimony is still ahead. At what point does silence stop protecting people and start protecting something else? That question doesn't get asked out loud very often. It sits beneath conversations, beneath family agreements, beneath the unspoken rules that govern what stays inside and what's allowed to escape. And once law enforcement becomes involved, that question turns sharp, because silence, in an investigation, is never neutral. After the arrest, after the initial shock calcified into something heavier and more procedural, the case entered a different phase. Not the dramatic phase the public imagines. No sudden reveals, no cinematic confrontations, but a quieter one. The phase where investigators listen more than they talk, where they read between answers, where they pay attention not just to what's said, but to how quickly it's said, how confidently, how consistently. This is where silence begins to mean different things to different people. To a family, silence can be survival. To police, silence can be strategy. To the public, silence is often interpreted as guilt or avoidance, even when it's neither. And to the person choosing it, silence can be the only way to stay intact. In the days following the arrest, there was a noticeable absence in the media narrative. One voice, in particular, never appeared. No statement, no carefully worded expression of grief, no attempt to shape the story. The youngest daughter remained out of sight. That absence was not accidental. In high-profile cases involving family members, legal counsel almost always advises restraint. Anything said publicly can be used later, misinterpreted, replayed, stripped of context. But legal advice alone doesn't explain the depth of this silence. Because there's another layer here. When someone speaks once, decisively, to law enforcement, and then chooses not to speak again, it suggests a line has been drawn. Everything that needed to be said was said. Everything else carries risk. That kind of restraint is not passive. It's deliberate. And it often means the person understands more about what's coming than anyone else realizes. Investigators, meanwhile, were doing what they always do in cases like this, building a structure strong enough to hold in court. That structure doesn't rely on emotion. It relies on corroboration. Timelines had to align. Physical evidence had to match statements. Movements had to make sense within the geography of the property. And perhaps most importantly, early impressions had to survive scrutiny. This is where cases can falter, not in the chaos of the first night, but in the calm that follows. When assumptions harden too early, when narratives settle before they've been tested. Good investigators resist that. They revisit early conclusions. They stress test their own theories. They ask the same questions again, months later, and listen for different answers. And when they do, silence becomes part of the evidence. Because silence isn't empty. It has shape. It has duration. It has consistency. In this case, the consistency of one family member's silence stands in contrast to the speed with which everything else moved. Charges filed quickly, details released selectively, public interest escalating almost immediately. Against that backdrop, one voice remained conspicuously absent. Not evasive. Absent. That distinction matters. Absence suggests withdrawal, not avoidance. It suggests an understanding that public engagement would not clarify anything and might distort everything. There's another uncomfortable possibility here. Silence can also indicate fear. Not fear of legal consequence, necessarily, but fear of escalation. Fear of being pulled into a media cycle that flattens nuance and punishes restraint. Fear of being forced to relive something that has already taken enough. We don't know which of these applies, but we know this. Silence, in this case, did not stop the investigation from moving forward. In fact, it may have sharpened it. Because when someone speaks carefully once, investigators tend to listen more closely to what they didn't say. They compare early statements with later evidence. They examine phrasing. They ask why certain words were chosen and others weren't. And when a phrase like dangerous family member appears early, it doesn't get forgotten. It gets cataloged, revisited, contextualized. That phrase alone would have prompted a cascade of follow-up questions. What made you choose that word? When did you first feel that way? Did others in the family share that concern? Was there an incident that made it worse? Or was it a slow realization? Those questions don't have to be answered publicly to shape an investigation. They only have to be answered once, honestly. And once they are, silence afterward doesn't erase them. It preserves them. This is where the case becomes less about spectacle and more about pressure. Legal pressure. Emotional pressure. The pressure of knowing that whatever you say next could alter not just the outcome of a trial, but the way your parents are remembered, the way your family is perceived, the way your own life unfolds. People underestimate how heavy that responsibility is. They assume speaking out is cathartic. Sometimes it is. Sometimes it's unbearable. And sometimes the only way to survive is to let the system do its work while you stay out of its glare. That choice, to step back, doesn't make someone weak. It makes them strategic. As the months move forward, this case will inevitably enter a more visible phase. Court appearances, motions, arguments over evidence. And when that happens, the pressure to speak will intensify. The public will want clarity. The media will want quotes. Speculation will harden into opinion. And silence will become harder to maintain. That's when its meaning will shift again. Because silence at the beginning of a case can be read as shock. Silence in the middle of a case can be read as calculation. Silence near the end of a case can be read as resignation. Where this silence will land is still unknown. But its presence now is not incidental. It is part of the story. And it stands in contrast to something else that has been happening quietly in parallel. The legal machinery has been moving. Evidence is being tested. Timelines are being locked in. And one central question is becoming harder to ignore. If danger was perceived early, why now? Why did everything converge on this moment? What changed? Because families can manage tension for years, decades even. They can normalize discomfort until it becomes background. So what disrupted that equilibrium? Was it a specific event? A conversation? A realization that something had crossed from manageable to uncontainable? Those answers haven't surfaced publicly, but they exist somewhere. And they will matter. Because when this case finally moves into a courtroom, it won't just be about what happened on one night. It will be about whether what happened was foreseeable, whether warning signs were present, whether assessments of danger were reasonable, and whether silence before the crime can coexist with certainty after it. That's a difficult line to walk. It's also a line the prosecution and defense will approach from very different angles. One will argue inevitability. The other will argue surprise. And somewhere between those arguments sits a family history that doesn't belong to either side, but will be dissected by both. As we move closer to that phase, remember this. The loudest moments of this case may still be ahead, but the quietest moments are already telling us something. They're telling us that not everything needs to be said to be known, and that sometimes the most consequential decision a person makes is not to speak again, because what they've already said has set everything in motion. What comes next will test that decision, because once the legal, it freezes the narrative at a moment when it was least contaminated by outside influence. Think about what happens when someone continues to speak over time. Their language shifts. Their emphasis changes. They clarify, revise, explain. That evolution is human. It's also exploitable. By choosing not to add to the record publicly, the youngest daughter effectively locked her contribution in place. Whatever she said exists as is, unexpanded, unreframed, which means it can't be contradicted by later commentary. That's not a coincidence. It's also not something most people would instinctively know to do, which raises another quiet implication. She understood the stakes immediately, not just emotionally, but legally. That understanding doesn't come from shock alone. It comes from context. Context about the family. Context about the person she warned police about. Context about what might happen if the situation escalated. And that context is something the legal system will try to extract piece by piece. Here's where things get uncomfortable again. Because once a case reaches this stage, family dynamics stop being private history and start becoming evidence. Not in the sensational sense. No courtroom theatrics, no shouting matches, but in a colder, more invasive way. Messages get reviewed. Call logs get analyzed. Patterns of contact get mapped. Who spoke to whom after certain events? Who avoided whom? Who checked in? Who didn't? These patterns don't prove guilt, but they do establish relational reality. And relational reality matters when intent is on trial. If someone is accused of acting deliberately, the prosecution will want to show emotional buildup, escalation, friction. If someone is accused unfairly, the defense will want to show misinterpretation, bias, pre-existing assumptions. And assumptions, especially family assumptions, are tricky because they feel true even when they're incomplete. This is why silence becomes a battleground. Silence can be framed as composure or avoidance, as dignity or calculation, as trauma or strategy. And the same silence can be read differently depending on who is interpreting it. That's not speculation. That's courtroom reality. As filings move forward, as motions begin to surface, we'll likely see early attempts to control narrative framing. What evidence is admissible? What statements can be referenced? What characterizations are allowed? And buried inside those arguments will be an unspoken struggle over one thing. Whose version of danger is credible? Was danger obvious only in hindsight? Or was it apparent enough that someone inside the family felt compelled to name it before law enforcement did? That distinction could reshape the entire case. Because if danger was recognized early, it raises questions about foreseeability. If danger was not recognized until after the fact, it raises questions about shock and misattribution. The law treats those scenarios very differently. So expect this tension to surface again, not in headlines, but in legal language. Words like reasonable, perceived, consistent, credible. Those are the words that will matter next. And they're the words that will quietly orbit around that early phrase. Dangerous family member, whether it's quoted directly or not. There's another layer to this that hasn't been discussed publicly, but investigators are undoubtedly aware of. High-profile families often develop internal hierarchies of credibility. Certain voices are trusted more than others. Certain concerns are taken more seriously. Age plays a role. Position plays a role. History plays a role. Being the youngest can mean being underestimated. It can also mean seeing things others overlook. That paradox, dismissed but observant, is not uncommon. And it complicates how statements are evaluated after the fact. Did others share her concern? Or did they minimize it? Did she speak up before? Or did she hold back until she felt there was no other option? Those answers, if they emerge, will not be comfortable for anyone involved, because they force a confrontation with missed opportunities, with moments when things might have gone differently. The legal system doesn't assign guilt for missed opportunities, but families do. And that internal reckoning doesn't end when a trial begins. It intensifies. As we move closer to the courtroom phase, one thing becomes increasingly clear. This case is not going to hinge on a single piece of evidence. It's going to hinge on interpretation, of timelines, of relationships, of silence, and of early judgment. The public will continue to look for a decisive moment, a revelation, a smoking gun, but the people inside this case know better. They know that what matters most is whether the story they're telling makes sense under pressure, whether it holds when challenged, whether it survives contradiction, and whether the quiet choices made early, to speak once, to stop speaking, to act quickly, to slow down, align with the version of events being presented now. Because inconsistency is fatal in court, and silence, paradoxically, can be the most consistent position of all. The next phase will not be about what happened. It will be about why it happened, and about whether that why can be proven, not just felt. As that battle takes shape, attention will shift again, away from the house, away from the night, toward the people who will eventually have to answer questions under oath. And when that happens, the difference between speaking early and speaking often will become stark, because the record doesn't forget, and silence, once broken, can never be restored. The question now isn't whether more will be said. It's who will be forced to say it, and under what terms. Because when this case finally reaches that point, restraint will no longer be optional, and the quiet that has defined it so far will face its first real test. What happens when the story stops being controlled by the family and starts being controlled by the record? That's the shift most people don't feel until it's already happened. One day, you're navigating grief, shock, disbelief. The next, your life is being translated into exhibits, timelines, and sworn statements, stripped of tone, stripped of hesitation, stripped of the human pauses that once softened everything. That shift has already begun here, quietly, and once it begins, there's no reversing it. Because the legal record doesn't care about intention the way families do. It doesn't care about love or history or how complicated relationships can be. It cares about consistency, about whether actions line up with claims, about whether fear was reasonable or retrospective. This is where the case enters its most dangerous terrain. Not emotionally, legally. After the initial arrest, investigators didn't stop working just because charges were filed. In fact, that's when the work becomes more surgical, less visible, less forgiving. Early assumptions are no longer enough. Everything has to be rebuilt in a way that will survive cross-examination. And that process has a way of pulling people back into the center, even if they've tried to stay on the edges. Especially if they spoke early. Especially if they used language that implies foresight. This is where the youngest daughter's early assessment becomes a pressure point rather than a footnote. Because when prosecutors prepare a case involving intent, they don't just ask what happened. They ask what was known, what was suspected, what was feared, and crucially, whether those fears were shared, documented, or acted upon before the crime. That distinction matters more than people realize. If concern existed but was never expressed, it becomes grief. If concern existed and was expressed privately, it becomes context. If concern existed and was expressed to law enforcement, it becomes evidence. That's not a moral judgment. It's a legal reality. And once something becomes evidence, it takes on a life of its own. The phrase, dangerous family member, is no longer just a description. It's a data point, one that will be examined for tone, timing, and justification. Defense attorneys will ask, what made you believe this? Prosecutors will ask, how long had you believed this? And both sides will want to know, did anyone else agree? That's where silence becomes fragile. Because silence doesn't answer questions. It just delays them. At some point, and this is inevitable, the system will demand more. Not from everyone, but from those whose early actions shaped the investigation. This is the paradox at the heart of the case. The decision to speak early, then retreat, may have been the safest choice emotionally. It may even have been the wisest choice legally, at least at first. But it also means that when the silence is eventually broken, if it is, it will carry disproportionate weight. Late testimony always does. Jurors listen differently to someone who waited. They ask why. They look for calculation, even when there was none. They assume strategy where there may have been survival. That's not fair. But it's how human perception works under oath. This is why cases like this rarely resolve cleanly. They don't hinge on one lie or one truth. They hinge on timing. On whether concern preceded tragedy or followed it. On whether silence protected people or protected assumptions. There's another element that's beginning to surface quietly in the background. Memory. Not memory as in recollection, memory as in reconstruction. Trauma alters memory. Stress distorts it. And grief reshapes it in ways people don't always recognize until they're confronted with their own words months later. Investigators know this. So do defense teams. That's why early statements are gold. They're closer to the event, less filtered, less reworked, but they're also less complete. People speak from instinct before they speak from reflection. And instinct doesn't always tell the whole story. That creates a tension that's difficult to resolve. What if an early assessment was accurate, but incomplete? What if danger was real, but misunderstood? What if the instinct was correct, but the reasoning behind it was flawed? The law is not good at handling nuance like that. It wants clean conclusions. It wants to know whether the fear was reasonable under the circumstances. And reasonableness is judged from the outside, long after the moment has passed. This is where family dynamics resurface again, but in a more unforgiving form. Not as feelings, as patterns. Who had conflicts with whom? Who avoided whom? Who felt threatened, and who felt frustrated? Who felt responsible, and who felt overwhelmed? These patterns don't prove anything by themselves, but they create a narrative scaffold. And once a scaffold exists, everything else gets hung on it. This is why some families fracture completely during legal proceedings. Not because they don't love each other, but because the system forces them to choose versions of events that can't coexist. One version becomes legally useful, another becomes emotionally necessary, and rarely are they the same. As filings progress, as attorneys prepare arguments, there will be pressure, subtle at first, for alignment. Alignment of stories, alignment of tone, alignment of interpretation. People will be encouraged, sometimes gently, sometimes not, to stick to what they've already said, to avoid elaboration, to avoid speculation, to avoid contradiction. That pressure is exhausting, and it weighs heaviest on those who are trying to stay out of the spotlight while knowing they may eventually be pulled back in. Because silence can't last forever when a trial looms. At some point, the record demands completion. That's when restraint stops being protective and starts being interrogated. Why didn't you say more? Why didn't you clarify? Why didn't you warn someone else? Why did you wait? These questions sound accusatory, even when they're procedural, and answering them requires a level of exposure that many people are not prepared for, especially when the exposure risks reframing grief as culpability. This is the stage where cases become emotionally cruel, not intentionally, systemically, because the system is not designed to preserve dignity. It's designed to resolve disputes. And resolution often comes at the cost of personal complexity. As we stand now, this case is approaching that threshold. The moment when silence is no longer just a choice, but a position that will be evaluated, challenged, and potentially dismantled. The moment when early words will be replayed, parsed, and tested against everything that came after. And when the youngest voice, the one that spoke first and then withdrew, may be asked to speak again, not on her own terms, but on the system's. When that happens, the story will change again. Because testimony under oath is not storytelling. It's exposure. And it forces people to reconcile what they felt then with what they know now. That reconciliation is rarely smooth. And it often reveals fractures no one intended to show. The question isn't whether this case will reach that point. It's when. And what will be lost in the process. Because once silence is broken in a courtroom, it doesn't just answer questions. It creates new ones. Questions that can't be contained within family walls. Questions that echo far beyond the case itself. And the most unsettling possibility of all is this. What if the earliest warning turns out to have been both right and insufficient? What if recognizing danger didn't mean understanding it? And what if the truth, when it finally emerges, complicates everything that's been assumed so far? That's the edge this case is approaching now. And the next turn will not be gentle. Because once the legal process demands clarity, ambiguity stops being tolerated. And the quiet balance that is held so far is about to be tested in a very public way. What happens when the story you've lived collides with the story the courtroom needs? That collision is coming. And you can feel it in the way the language around this case is beginning to tighten. Fewer adjectives, more qualifiers. Words like allegedly, purportedly, according to filings. The human messiness is being compressed into something narrower, more rigid, more survivable under cross-examination. This is the stage where reality starts to get edited. Not by the media this time, by lawyers. Because once the case moves toward trial, everything becomes about what can be proven, not what was felt. About what can be shown, not what was sensed. And that shift is brutal for people whose understanding of danger came from intuition rather than documentation. Intuition doesn't photograph well. It doesn't timestamp cleanly. And it doesn't always translate into the kind of evidence juries are trained to trust. That's the tension tightening around this case now. On one side, there is a version of events shaped by lived experience, by accumulated moments, by instincts formed over time. On the other, there is a version of events that must fit into a legal framework that demands clarity, sequence, and motive. Those two versions rarely align perfectly, and when they don't, something has to give. Behind the scenes, attorneys on both sides are beginning to prepare for that misalignment. The prosecution's task is not simply to show that something terrible happened. That part is not in dispute. Their task is to demonstrate that what happened followed a logic of intent. That it was not impulsive, not accidental, not misunderstood. Intent is a heavy word. It requires a narrative that stretches backward, a story that begins before the crime itself, which means everything before the night in question suddenly matters more. Every argument, every estrangement, every sign of instability, if it can be framed that way. But the defense will push in the opposite direction. They will look for ambiguity, for alternative explanations, for emotional misreadings, for fear that grew faster than facts. They will argue that perception is not proof, and that early assumptions, especially under trauma, can harden into certainty even when they shouldn't. This is where the youngest daughter's early role becomes a legal fault line, not because she did something wrong, but because she did something decisive. She didn't hesitate. She didn't equivocate. She used a word that carries weight, and now that word exists independently of her. It belongs to the record. The record doesn't care why a word was chosen. It cares that it was. So now both sides will attempt to interpret it. Was it the product of long-held concern, finally voiced? Or was it the product of shock, looking for an explanation that felt familiar? That question will not be answered by emotion. It will be answered by corroboration. Who else, if anyone, shared that concern? Were there messages, conversations, warnings? Did anyone attempt to intervene before? Or did everyone, consciously or not, choose to manage things privately? This is where family silence stops being neutral and starts being scrutinized. Because silence can be read as absence of concern, or it can be read as evidence of containment. And the difference between those readings matters enormously in court. If concern existed but was never escalated, the defense can argue it wasn't seen as urgent. If concern existed and was escalated only at the moment of crisis, the prosecution can argue it was finally unavoidable. The same facts, different meanings. This is why the middle period, the time before the night, is becoming the most contested terrain of this case. Not publicly yet, but soon. Because juries don't just judge actions, they judge reasonableness. Was it reasonable to fear danger? Was it reasonable not to act earlier? Was it reasonable to interpret what happened the way it was interpreted? Reasonableness is a slippery concept. It changes depending on context, perspective, and hindsight. And hindsight is ruthless. It makes everything look obvious. But obviousness after the fact does not mean inevitability before it. This is what the courtroom will struggle with. And it's what the family will be forced to confront, whether they want to or not. There's another factor complicating this phase, one that doesn't get discussed openly, but is always present. Public expectation. High-profile cases carry an unspoken demand for resolution, for clarity, for accountability. People want to know who to blame. They want a clean ending. The legal system pretends to be insulated from that pressure. It isn't. Prosecutors feel it. Judges feel it. Even defense attorneys feel it, though in a different way. And families feel it most of all. Because once a narrative forms publicly, deviating from it becomes costly. Silence starts to look suspicious. Nuance starts to look evasive. And grief starts to look strategic. None of that is fair, but it's real. This is why the upcoming phase of this case will likely feel colder, sharper, less human. Not because the people involved have stopped feeling, but because the system they're entering has no space for feeling unless it can be justified. Every emotion must be anchored to a fact. Every concern must be traceable. Every instinct must be defended. That's exhausting, and it changes people. Those who have followed similar cases know this pattern well. The longer a case stretches on, the more people retreat into roles. The accuser, the accused, the witness, the silent one. Once those roles solidify, breaking out of them becomes nearly impossible. And right now, those roles are still